Hi, welcome to this video which explains the model clauses which are designed for supplier to subcontractor. So both under the General Data Protection Act 1998, which is in force until the 24th of May 2018, and the General Data Protection Regulation 2018, in force on the 25th of May 2018, organisations have to ensure that data receives an adequate level of protection whenever it is processed overseas. This includes any processing by contractors to their subcontractors by putting in place appropriate privacy-compliant data mechanisms. So these clauses are described as ad hoc because there are various mechanisms available under the legislation which allow for adequacy findings. So some of these are that there is a data transfer agreement, that there are model clauses in place, or that Privacy Shield for US transfers or another mechanism is available, such as a European Community finding of adequacy. While the model clauses for controllers to controllers and for controllers to processors, so customers to suppliers, have a finding of adequacy, an automatic finding of adequacy, if they're entered into without any amendment, the ad hoc contractual clauses, although drafted by the European Commission, have not had a finding of adequacy with them. However, they are very likely to meet the requirements of processing requirements of the relevant privacy legislation because they are an EU document. So these clauses are designed to ensure that whenever a processor subcontracts to a non-EU sub-processor, so maybe outsourcing to India or the Philippines, which is quite common in IT scenarios or HR, the data receives an adequate level of protection. So this template sets out details of the transfer, the third-party beneficiary clauses, obligations of the data exporter, obligations of the importer, liability, mediation and jurisdiction, cooperation with supervisory authorities, governing law, variations of the contract, sub-processing, obligations after termination of the personal data processing to ensure that data is disposed of lawfully, details of the transfer that's actually taking place, and details of the technical and organisational security measures which need to be put in place to keep the data secure. All of these things are requirements of the clauses to ensure that the findings around data security contained in the legislation are being met. We hope you found this agreement useful. If you need advice on your subcontracting arrangements more generally, please do let us know, as quite commonly the liability positions and whether your subcontractors reserve the right to process overseas without your consent are quite frequently contained in standard terms and conditions, especially for off-the-shelf type products. So it's very important to ensure you have a look at that because under the GDPR, data processors for the first time have direct liability. So you will face regulatory sanction and potentially investigations in the event of a data breach. It's also important because your customers will be seeking to flow down more data privacy requirements to you to discharge their own obligations under the GDPR, and that might also have implications for your liability position. If you're unsure of what this might mean for your business, please do feel free to get in contact with us via our website, and we can help you to go through your agreements and understand better your next steps.